Now I'm going to deliberate on an important topic. No one would have thought of today's situation, but today, if you see that situation literally got developed to the level which we have not thought of, that a scheme of amalgamation, it can be done even under the Insolvency Bankruptcy Code. But earlier, the scheme of amalgamation or demerger under section 230 and 232 was contemplated. Of course, under 1956, as you all aware, the scheme were contemplated under section 390 to 395. Now, after Companies Act 2013, any scheme, whether it's amalgamation or a demerger or any arrangement or compromise, it's contemplated under section 230, could be contemplated under section 230, 231 and 232. 233, as you all know, that small company and fast track merger can be carried out under section 233. Now the position is little more has got evolved, wherein we were contemplating the scheme of amalgamation or scheme of arrangement or restructuring earlier only under the provisions of the Companies Act 2013, whereas now the situation has evolved that the similar scheme, whether it's amalgamation or demerger or restructuring, corporate restructuring, is very much possible under the provisions of Insolvency Bankruptcy Code 2016. Before completion of my deliberation, I wanted to give a complete picture on how a scheme can be contemplated and today how it could be contemplated under the provisions of Insolvency Code, read with the provisions of the Companies Act 2013. See, earlier, as I was referring, the scheme of amalgamation demerger generally be contemplated under the provisions of Companies Act for a different reason, right? For corporate restructuring and various other reasons, takeover and many other reasons. But now, after Insolvency Bankruptcy Code, you all know that the Insolvency Bankruptcy Code has been introduced with effect from 1st December 2016, which it came into effect after the establishment of NCLT. Now what happened? The Insolvency Bankruptcy Code has been introduced to address the financial failures of the corporate. So though we have a different enactment, you know that the Provincial Insolvency Act and the Presidential Insolvency Act and the BAFR, SICA provisions were there earlier to take care of, even winding up under the provisions of Companies Act were there to take care of all these aspects. But government, in order to give a single solution, a single piece of legislation which addresses all the financial failures of corporate debtor in our country. All financial failures of the corporate debtor in our country. So now a government took initiative and introduced a complete code to address the entire financial failures in our country by corporate. Of course, individuals also now to limited extent it has been notified. Now, this particular deliberation is to see that how the scheme of amalgamation or demerger restructure can be contemplated even under the provisions of the Insolvency Bankruptcy Code. Referring that earlier it was under the provisions of 2013 Act, now also under Insolvency Bankruptcy Code. Now, when there is a default, the Insolvency Code has come into effect, as I was told you. There are three segments. One is a financial creditor, operation creditor and corporate debtor, section 7, 9 and 10. 7, financial creditor can initiate, operation creditor can initiate section 9. Corporate debtor can, voluntarily they can initiate a CIRP process by passing a specification under section 10. Now, after initiation of this, how the process works? Once there is a default, the financial creditor, namely the banks or financial institution, they initiate the CIRP process. Once the CIRP process initiate, means the application is filed under section 7. NCLT, the adjudicating authority, hears the application and it passes the order if it is complete in all respect, and the NCLT and satisfied that it's a fit case to initiate the CIRP process. After initiating CIRP process, what happened? The process is taken control by the IRP, then after that it is succeeded by the RP. Then once the RP takes over the control of the operations and corporate debtor, he has to come out with the invitation of expression of interest for inviting the resolution plan. Okay, now the situation comes for revival of company. In fact, the RP has to invite the resolution plan for revival of the corporate debtor which has come into the CIRP process. Now, the law now went up to the level where the code provides that today the resolution plan also can be given in the form of merger, demerger and corporate restructuring. The meaning that the resolution plan is nothing but if the company is under CIRP, now to revive the company, the invitation can be given to the outsiders, wherein any outsider, they call resolution applicant who are proposing to give a resolution plan. Now the code was contemplating originally a resolution plan to revive the scheme, revive the company, corporate debtor. Now subsequently the code got amended to include the resolution plan also can be given, which includes scheme of merger, demerger. So here only the process starts, the whole concept starts. Now earlier what was possible only under the provision of Companies Act, now it's possible even under the provisions of the Insolvency and Bankruptcy Code. Now since the code has got amended that the resolution plan can be given under Insolvency and Bankruptcy Code involving the merger, demerger, now a resolution plan can be given capitalizing, wrapping inside the resolution plan the scheme of amalgamation or demerger to see that the corporate debtor is revived and comes to the new management, in the hands of the new management. Therefore, it is very much possible even under the CIRP stage, a company can get into the amalgamation process or demerger process or a rearrangement process whereby by implementing the resolution plan in the form of the amalgamation demerger, a corporate debtor can be merged with a new company or a division of the corporate debtor can be demerged, and even another company can be merged with the corporate debtor to see that corporate debtor is revived. So any methods of the scheme can be contemplated in the resolution plan itself. Fine. Now, before this got evolved, that a scheme can be contemplated even during the liquidation. Today the position is that a scheme of amalgamation demerger also can be contemplated during the liquidation. Now the situation from CIRP level, it got evolved. Even the scheme can be now contemplated in liquidation stage. How? In fact, in one of the important judgment wherein the Honourable NCLAT has passed an order that Liquidator, it is a scheme of Amit Gupta, IP is Mr. Amit Gupta. That scheme, the Honourable NCLAT has passed an order stating that the liquidator shall proceed with the scheme under section 230 before proceeding of liquidation of the corporate debtor. So wherein the Honourable NCLAT, the Honourable National Company Law Appellate Tribunal, they went up to said that the purpose of the IBC itself, if you see the preamble itself, the preamble does not say the context called, the process called liquidation. So then, because it has been observed by Honourable Supreme Court in Switzerland that the preamble itself is not contemplating on liquidation, the preamble of the Insolvency and Bankruptcy Code itself to revive the corporate debtor. So therefore, taking reference from that, the Honourable NCLAT has passed an order, even one in Amit Gupta and another in Shivram Prasad case, when it made it very clear that the liquidator is directed to take steps to implement a scheme process under section 230 before proceeding to liquidation process. Now, after this order, immediately the respected Insolvency Bankruptcy Board has came out with the regulation of Regulation 2B, wherein it provides that the liquidator shall, before commencing with the process of liquidation, he has to see that he is exploring the possibility of the implementation of scheme or getting the approval of scheme if the scheme has been given to the liquidator. So there's a time limit is given that the scheme has to be completed within 90 days from the date of liquidation commencement date. So after exploring that 90 days, then only the liquidator will be at liberty to initiate the liquidation process. Without exploring this, the liquidator, provided the scheme is in hand. Okay, if there is no scheme, then liquidator can proceed. If the scheme is given in hand, that means if any stakeholder, any outside person has submitted a scheme, then liquidator has to first explore whether any scheme is contemplated as submitted during the liquidation. Immediately order is passed, he is getting implemented the scheme and getting the approval of the scheme within 90 days time, then to move on with the scheme process, or in case the scheme is not in place, then move on with the liquidation process. So today the situation is that even during the liquidation period also, generally during the liquidation period, the liquidator will make sure that he renders the function as provided under section 35, whatever the functions are specified under the Insolvency Code under section 35. Liquidator will ensure that he start the process, give the paper publication, the commencement of liquidation, then invite the claim, then accept the claim, adjudicate the claim, then he will move on with the e-action process. Then after the e-action process, then once the sale process comes, he starts distributing in tune to the provisions of the section 53 of the Insolvency Bankruptcy Code. So this is how the role, the functions of the liquidator, what is described under the Insolvency Bankruptcy Code. Now, the real development, the new development that has come today is that the amalgamation can be carried out, the demerger or restructuring can be carried out not only under the provisions of Companies Act, not only the normal companies which is function in a normal way, it is also possible for the company which comes under the CIRP process to make sure that the company structure is altered and corporate structure is changed to suit to the new requirement of the management. And even if it is not happening in the CIRP, now the law has got evolved, the Insolvency Bankruptcy Code has got evolved to the level, even after CIRP, even during the liquidation period also, a scheme of amalgamation can be contemplated, and it becomes the responsibility and duty of the liquidator to see that he is first endeavoring and giving effort to see that a scheme is implemented. If the scheme is submitted to the liquidator and the liquidator takes approval of the Honourable Adjudicating Authority within 90 days time and implement the scheme, failing which the liquidator should proceed with the liquidation process. So therefore, now the scenario is that it's not that once the company enters into CIRP process, there ends and nothing can be done for the revival. Now the law provides for not only the revival of the company only pursuant to the provisions of the Insolvency Bankruptcy Code, the law has also got evolved that the company can be revived under IBC code by contemplating the scheme in compliance with in pursuant to the provisions of section 230 of the Companies Act 2013. And not only during the period of CIRP process, Corporate Insolvency Resolution Process, even after CIRP process gets over, during the time frame of the liquidation also, the scheme can be contemplated, and if the scheme is approved by Honourable Adjudicating Authority, then the scheme has to be implemented as per the direction given by the Honourable Adjudicating Authority. Therefore, now a scheme and restructuring process is possible and can be contemplated not only under the provisions of Companies Act, it is very much possible under the provisions of Insolvency Bankruptcy Code, read with the section 230. And as you all aware, section 230 has got a wide power wherein under section 230 and a company can contemplate a scheme of arrangement, scheme of compromise and amalgamation, demerger. Even today, it also can contemplate reduction of capital. So section 230 of the Companies Act is wide enough today to do all kind of corporate restructuring. Today, since the Insolvency Bankruptcy Code has got evolved to the level that whatever could be contemplated under section 230 as provided under the Insolvency Bankruptcy Code and Honourable NCLAT order, today the same process also can be implemented in the provisions of the during the process of the CIRP and during the process of the liquidation. Therefore, it is a really blessing. It will be a blessing to the new management that whoever takes over the company from the old management under the Insolvency Bankruptcy Code can see that they're altering the entire structure of the corporate debtor to suit the requirement and make sure that they are rendering a scheme, contemplating a scheme in tune to the provisions of section 230 and 231 and 232, and see that the new management literally get the benefit of the provisions relating to the scheme of compromise and arrangement. And today that benefit is not only available to the regular running companies who is rendering their business, doing their business. That privilege and benefit is also extended to the companies which has come under CIRP and which has come under liquidation process. Therefore, this could better be utilized by the new management whoever taking initiative to acquire the company during the CIRP by submitting the resolution plan or by submitting the scheme during the liquidation plan. So it is really a welcoming measure that the government has done. In fact, this opportunity should really be utilized by the new management whoever endeavoring to acquire the management or revive the corporate debtor in tune to the provisions of the Insolvency Bankruptcy Code. So I thought this information would be much useful to you, because this is something, the recent development that has taken place after the Insolvency Bankruptcy Code. Because Insolvency Bankruptcy Code originally was not carrying this option. This option has evolved after a number of orders has been passed by Honourable NCLAT and amendments carried out in the regulations. So this is the information I thought would be more useful to you, and thanks for hearing. See you again. Bye.